How's it going? It's all the news all the time, and there's a new story that's come out. This looks like an old story, and it did come out a few days ago, this first bit, which was Johnny Depp verdict has been thrown into chaos as the wrong juror was seated in the Virginia trial. Amber Heard says, and she wants a new trial. I'm sure you remember this happening a few days ago. If there wasn't enough drama swirling around Johnny Depp's win in this multi-million-dollar defamation suit, things have turned judicially weird. Ms. Heard has a right to rely on the basic protection as prescribed by the Virginia Code that the jurors in this trial would be individuals who were actually summoned for jury duty. The statement in this article is talking about juror number 15, who was, they say, the wrong juror. It seems an invitation or a demand, a subpoena for that juror to attend and do his civil duty was actually taken over by someone else at the same address. It was given to someone who was 77 years old, but someone who was 52 years old actually attended the court. They both had the same name. They lived together. They are probably, almost definitely, of the same family, but they're different people. So Amber Heard is arguing that this should be a ground, or this should be grounds for a mistrial. And I was thinking to myself, well, this does seem viable. Seems like a viable claim. But then we actually look to the response by Johnny Depp's team, which came out today. And it says Johnny Depp rejects Amber Heard's frivolous aim to toss the trial verdict as too little too late. The pirate star claims the Aquaman star knew about the jury discrepancy. Well, just a few days after Amber Heard filed new paperwork to have Johnny Depp's defamation trial verdict tossed out and a new trial set, the current Jeff Beck sideman, that's a weird way of describing Johnny Depp, Jeff Beck sideman, has responded. Unsurprisingly, the lengthy response from Team Depp is to maintain the multi-million-dollar decision, insisting that the Virginia court reject Ms. Heard's baseless contention over his more than $10 million damages award and everything else. Following a 6-week jury trial, a jury of Ms. Heard's peers rendered a verdict against her in virtually all respects, says the memorandum, in opposition from Depp's Brown Rudnick attorneys Monday. Though understandably displeased with the outcome of the trial, Ms. Heard has identified no legitimate basis to set aside in any respect the jury's decision. The filing in Fairfax County claims Virginia law is clear that a verdict is not to be set aside unless it is plainly wrong or without evidence to support it. The memo adds, and the memo is here. This is the memo filed with the Virginia court in the Circuit Court of Fairfax County in the name of John C. Depp II as plaintiff and counterclaim, and Amber Laura Heard, defendant, counterclaim, and Wicked Witch of the West. As you can see here, table of contents, introduction. The damages awarded by the jury were supported by the evidence and law. The verdicts on the complaint and counterclaim are consistent. The First Amendment does not bar recovery for defamation by implication, even when the statements at issue involve public figures or matter of public concern. The jury's finding of defamation regarding the op-ed headline was consistent with and supported by the law and facts. The jury's finding of actual malice is well supported in the record. Mr. Depp presented sufficient evidence to support a finding of defamation by innuendo. The court should not conduct an investigation of Juror 15 because the defendant has waived such arguments and has failed to provide any evidence of unfair prejudice or any due process violation. Looking at the memo itself, we have a brief introduction to the claim made, or the response made by Depp's team. And they're clearly saying Virginia law is clear that a verdict is not to be set aside unless it is plainly wrong or without evidence to support it. And here the verdict was well supported by overwhelming evidence consistent with the law, should not be set aside. And then if we move on to the damages, the court should reject the claim because under Virginia law, the court may only correct a verdict when it is so excessive as to shock the conscience of the court or to compel the conclusion that the verdict was the product of passion or prejudice or some misunderstanding of the facts or the law. And they're citing the case of Hogan and Carter 226 VA. So it must be so excessive as to shock the conscience of the court. Well, it isn't that. Or to compel the conclusion that the verdict was the product of passion, no. Prejudice, no. Or some misunderstanding of the facts or law, no. It's none of those things. The court may not arbitrarily substitute its judgment for that of a jury. Yeah, that's a principle of law. In assessing the jury's verdict, the court is required to consider the evidence in the light most favourable to the party that received the jury verdict. Even more problematic for misheard. In assessing the verdict, the court is required to consider the evidence in the light most favourable to the party that received the jury verdict. So, it's not looking good for misheard. I think the term frivolous is quite acceptable. And we have an article from The Independent which speaks of the same thing. Johnny Depp has asked the judge to throw out Amber Heard's request for a new trial. In this, Depp's team argues that even if the juror mix-up is correct, the individual who sat on the panel and sided with him in the case was still vetted by the court. Even if Mrs. Heard had filed her supplementary memorandum in a timely manner, which she did not, or even had she not waived her right to raise this alleged issue by sitting on the information for more than 2 months, which she did, the court should still grant plaintiff's motion to strike defendant's supplementary memorandum because Mrs. Heard failed to cite any unfair prejudice, the documents say, which is what is needed. And if there is a situation where there's a benefit of the doubt, the court will always find for the winner of the case, in which case this is Mr. Depp. So this is a non-flyer for Mrs. Heard in any way, shape or form. So if you like what you've been seeing and you'd like to press the like button and the subscribe button, leave me a comment and let me know what you think. Is this just a crazy sort of last chance, grasping at straws sort of case for Heard? It does seem that way. It doesn't seem to be viable at all. But on that, I will catch you guys later.